Good afternoon. My name is Heather Nadler. I'm with the law firm of Nadler Biernath, and thank you so much for joining me today for this webinar. The webinar is being recorded, so for those of you who are watching it live, you will receive an email link within the next few days to give you the opportunity to watch it again if you would like to do so. And also, we are going to have a live question and answer session. We're going to hold questions until the end just to make sure we get through all of the material, and then I will be glad to hang around and answer any of those questions that you might have. You can see on your screen there will be a Q&A spot, so you can just click that and put your questions in there. Feel free to put them up as we are going through the presentation while you're thinking about it, and then I will address them at the end. So let's get going. First, just a little bit about me and our firm. At Nadler Biernath, we practice exclusively in the areas of elder law and special needs planning and estate planning. Of course, today we're going to be focusing on an elder law issue of financing long-term care. And a little bit about me, I've been practicing law since 2001 and doing just elder and special needs law since 2003. Graduated from Auburn for undergrad and got my law school from Tulane University School of Law. And because I'm a lawyer, I have to start with this and say as a legal disclosure that this presentation is for educational purposes only. It should not be construed as legal advice, and certainly is not a substitute for sitting down with an attorney and having all these rules applied to your particular fact circumstance. So a question that I get a lot of the time is elder law. What's elder law? And really, elder law is really about who we are serving, and then it can encompass a lot of different areas of the law. In particular, we do spend a lot of time doing basic estate planning, wills, trust, powers of attorney. You might have seen a previous webinar where my associate Laura Akins went into a lot of the details on that last month. And also we work with probate after clients pass away. We work with them on administering trusts if the trust has been used to avoid probate. So any manner of handling those estates. And then also guardianship. If people don't have capacity or haven't done advanced planning, then we work on guardianship. But today, in another area in which we spend a lot of time, we're going to be talking about financing long-term care. So you have several options in financing your long-term care, and these are the ones that we are going to go over here today. Private pay, using long-term care insurance, what does Medicare cover, what VA benefits are available, and then how Medicaid determines eligibility and helps with paying for the cost of care. So first and foremost, of course, we have private pay. If you've got cash in your pocket, it can be easy to find the care that you need if you're able to pay for it privately. So just to give you an idea of what you might expect in that arena, 24-hour a day in-home skilled care can easily cost, $120,000 a year, and really more realistically, I would say probably about $144,000 a year. About $10,000 to $12,000 a month is what is required if you need someone in your home to help you with hands-on care 24 hours a day. The average cost for assisted living in Atlanta was approximately $45,000 for 2019, so about $3,800 a month. That is very much a base starting price when it comes to assisted living. A lot of times once you are in assisted living, there are then a la carte fees that get added on a monthly basis. So you can easily look more in the neighborhood of about $5,000 a month for private pay for assisted living care. The average cost for a nursing home in Georgia, this is statewide, is about $102,000 per year, or about $8,500 a month. And remember that number because it will become relevant as we talk further about Medicaid eligibility and Medicaid planning. So long-term care insurance. One of the things that I love about long-term care insurance is that it allows an individual to retain control of long-term care. In particular, long-term care will help cover services if your policy allows for it, which I would recommend that you do have that in place. If you do get a long-term care insurance policy, be sure to ask, what does this cover? Does it cover in-home? Does it cover assisted living? Because when we get to Medicaid in a little bit here, you'll be hearing how Medicaid only covers, realistically, for seniors in Georgia, nursing home level care. And sometimes that's the very last place that you want to receive your long-term care. And so if you can have a way to help finance care in-home or through assisted living, a lot of times that's preferable for people. So long-term care insurance, if you get the right policy, will enable you to do that. And long-term care insurance is even more important, I think, as far as the Medicaid system becoming strained and what can the states really continue to afford and provide. Really, usually long-term care insurance operates on a reimbursement model, which means you pay for the care that you need, and then your long-term care insurance will reimburse you for the amount of care that you paid out, typically on a monthly basis. So less and less these days am I seeing people who say, oh, well, I have Medicare. I'm going to be covered. I don't need to worry about my long-term care. Many years ago when I first started practicing, people kind of might have that impression more so than they do now. People now tend to realize that Medicare is not long-term care. Medicare is designed to cover acute illnesses, not chronic ones. So Medicare is really, you injure yourself, you get in, go to the hospital, get better, and move on with your life, hopefully going back to your regular everyday routines. And that is what Medicare anticipates. There is a limited home care benefit for skilled care, and typically that's going to be something that's prescribed for a period of weeks after there's been a hospital stay, like after there's been a surgery, if you need to have nurses or therapists come to the home and help. But it's even then, it's just going to be for limited visits. It's not going to be someone who is sitting at home with you and making sure that your meals are prepared, things of that nature. So now Medicare does offer a very limited nursing home benefit, and it only applies if you have had a 3-day hospital stay. Now, actually right now in the COVID environment, this 3-day hospital stay has been waived, and you're not required to be in the hospital for 3 days before moving on to a nursing home in order to get that Medicare coverage. But typically it is a 3-day stay. So where I see this play out for a lot of my clients is that someone has an event, whether often it's a fall or a bad bout of pneumonia or something where they have to be hospitalized. So they get hospitalized, and then if they spend 3 days in the hospital, then get discharged immediately to a rehab facility or a skilled nursing facility, then Medicare will cover a period of time for the care that they receive in that nursing home. Now, it's very important to go directly from the nursing home from the hospital to the nursing home. Whereas I've had clients who have, tried to go home for a little bit and a couple weeks pass and it's really not working out. And then it's difficult or impossible to get this continuing Medicare coverage. So even though it can intimidate a lot of people to say, gosh, well, I'm afraid that if I go over to that nursing home for that rehab, I might never come out, and I can certainly understand that fear. But nonetheless, important in order to get the therapy that you need to go directly from the hospital to the nursing home. So if that is the case, Medicare will cover the first 20 days, no questions asked. If you're there and you're trying to get better, you're rehabbing, then Medicare is going to cover the cost of your stay for the first 20 days. Then for day 21 through 100, those are potentially covered by Medicare if you are participating in therapy that is helping you get better or preventing you from getting worse. There's actually a Supreme Court case, United States Supreme Court case, that went all the way up with regard to enforcing that or preventing you from getting worse standard. So it's just not that you're doing therapy. It does not have to be therapy that's helping you get better. If it's helping you maintain or preventing you from getting worse, then that falls under that 21 to 100 day care criteria as well. Now, a lot of time, this is not a rubber stamp kind of thing. So don't think, okay, yeah, we'll get in, and they'll agree, they'll rubber stamp it and say that, oh yeah, sure, she's doing therapy. It is absolutely not a rubber stamp case. You've really got to be actively participating in therapy that is beneficial to you. one of the issues that I see with a lot of elderly clients who have dementia in particular is that if they are in the hospital and go to the nursing home and they're there for the 20 days and then come day 21, 22, whatever it is, if they cannot cognitively understand to participate in therapy or understand the importance of doing that therapy, maybe it's not dementia, maybe they're just ornery, that happens too, then those days through 21 through 100 are not going to be covered. And so I often encourage family members, you know, if it means that someone goes to therapy and acts as the cheerleading session in order to get that covered, you know, try something like that, just any encouragement, because you really do have to be participating in that therapy in order to continue to get the coverage. So with that, the days 21 through 100 can be covered, and notice that says with a copay. Well, with that copay, you know, when we think of copays, we tend to think, okay, I go to the doctor and I pay $20 or $30 and that's my copay. The copay here for Medicare nursing home coverage is pretty hefty. For 2021, it's $176 a day. So $5,000 a month. And a lot of people would say, well, that doesn't feel much like a copay, and I agree. Important to realize as you are shopping for Medicare supplements, especially as we approach here before too long open enrollment for Medicare supplement policies, is to find out, would the policy cover this copay? If I go to a nursing home and I am getting care beyond 20 days and Medicare is helping pay for that, will this Medicare supplement policy cover my copay to the tune of $176 a day? And a lot of them will, but it's just something to be cognizant of, because that can be a big surprise. You think, oh sure, Medicare is going to cover days 21 through 100, but then you're still going to get a bill for $5,000 a month during that period. So another benefit that can be, it's not available to everyone, it's not even available to all veterans, just some veterans, but it's the VA aid and attendance benefit. This can be very helpful when it comes to financing long-term care. So the VA aid and attendance benefit is available to wartime veterans, and it helps supplement the cost of care. And that care can be in-home care, it can be for assisted living care, and skilled nursing care if you were in a nursing home. But in order to qualify for this, you must satisfy certain financial eligibility criteria. So a lot like Medicare, it's not just like, oh, I've got Medicare, I'm fine. And likewise, it's not, oh, I'm a veteran, I'm fine. It has to be a wartime veteran, and then also satisfy the financial eligibility criteria. So the veteran, the wartime veteran, and the wartime dates are available if you were just to Google VA aid and attendance wartime dates. They're a little bit more lenient than you would probably expect. You don't have to have been boots on the ground. You could have been sitting behind a desk at a base here in the United States. It's just if you were enlisted for at least 90 days total, and one of those days has to be during a wartime period. And so you can look and see if it would be a date that you might not think would fall in that range actually does. So always worthwhile to check. So this benefit is available to the veteran, him or herself, as well as a widow or widower who is blind, living in a nursing home, or unable to perform activities of daily living. And so a lot of times it's that unable to perform activities of daily living that helps. You do have to get a medical certification and meet certain criteria. A doctor has to certify that you need this help. And then if you qualify, the benefits can range from about these figures, $1,230 to $2,266 a month, and that depends. The lowest benefit amount there is for a surviving spouse, and the highest benefit, the $2,266, is if it's a spouse, it's a veteran and a spouse, and the veteran needs that care, or if it's just the veteran, the benefit is somewhere in between. Now, you are not guaranteed to get the full amount to which you are entitled. You have to demonstrate a deficit, and that's where this next bullet point comes in. Your monthly medical expenses must exceed your monthly income. So it's not enough to say, hey, I'm a veteran and I meet these financial eligibility criteria. The next question is, okay, well, what are your monthly medical expenses? And if your monthly medical expenses are $5,000 and your income is $1,700, well, you're not going to qualify because you're not in the red each month as to income. However, if your income is $500 and your medical expenses are $1,200 a month, then you can get up to $700, not the total maximum amount that you potentially could receive, just whatever the shortfall is that you are demonstrating. So this is kind of an oversimplified approach to it, but it gives you an idea of how that works. Also, you must have less than $130,640 in countable resources in order to qualify for that. We're going to go into a lot of detail here in a minute about countable resources for Medicaid. The VA treats their countable resources a little bit differently, and since I'm focusing primarily on Medicaid eligibility here today, I'm not going to go into total detail on that. But the countable resources are relevant for VA benefits as well. The VA also has, only since October of 2018, does have a look back for making transfers. So up until 2018, you actually could say, okay, well, today I have $100,000 too much, so I'm going to take that and put it over into a family trust, or I'm going to give that to my kids. And then tomorrow I'm going to apply for VA. And that was a possibility. There was no look back, no penalty for giving away resources, which is very different than how Medicaid treats things. But then in October of 2018, the VA rules changed. And so now there is a look back, a 3-year look back. So at the time you apply for VA benefits, and if you say, okay, I've got $120,000 in countable resources, and so they look at it and they look at the income of the spouses and medical expenses, and they say, okay, yes, you're good to go, but have you given anything away in the past 3 years? And if you have, then there is going to be a penalty imposed for having done that. So in other words, now you can't just give assets away and then become eligible for VA the way that you could prior to 2018. All right, so where I want to spend the rest of our time here together is really taking a close look at nursing home Medicaid benefits. This is definitely what, as elder law attorneys, we get the most questions on and spend the most of our time advising clients on when it comes to long-term care. So the first thing to understand on nursing home Medicaid benefits is that it provides care for people who are aged. And I always tell folks, as much as we might disagree, Social Security's definition of aged is 65. So aged, blind, or disabled. And again, you've got to meet pretty stringent financial eligibility criteria. And that's what we're going to keep talking about. So first, applying for nursing home Medicaid benefits, Medicaid is going to look at the income of the individual who is seeking that nursing home care. And that income must be less than what the nursing home actually costs. So if you think back to the example I gave, or the number that I gave you earlier, which was the average private pay rate for a nursing home in Georgia is about $8,500 a month. As long as an individual's income is less than that amount, they can qualify. So it's pretty unusual for seniors who come to me where Medicaid might be a potential, pretty unusual for them to step into my office and for me to look at their intake forms and see that they do have $8,500 a month in income. So Medicaid is still a possibility for folks, even if you have $5,000 or $6,000 a month in income potentially. So as long as your income is less than what the nursing home actually costs, which typically is going to be that $8,500 a month figure, the statewide average is what gets used there, then you can qualify. Now, if the applicant's income is over this magic figure that gets set by Medicaid each year, this year for 2020, it's $2,349 per month. That figure does go up a little bit each year. It comes out in October, so we should know within the next few weeks what that new figure is going to be. It has been guesstimated by folks like AARP that there'll probably be about a 0.5% to a 1% increase for 2021. So even if it does go up, it's not much. But if the applicant's income is over the magic figure, which is known as the Medicaid income cap, then the individual can still be eligible, because remember, looking back up there at the first bullet point, it's actually as long as your income is less than what the nursing home costs, you can be eligible. But if you're over the $2,349, you have to set up a Miller trust or a qualified income trust. This is a silly hoop that is required to jump through in order to qualify. It doesn't change anything. It doesn't protect anything. Like you tend to think, oh, well, I hear the word trust, we must be protecting something. It's not. It's simply the income continues to come to the individual. You transfer it over into a trust each month and you pay the nursing home out of that. It's just a requirement. Like I said, a hoop that has to be jumped through. But as long as you set up that trust, and it can be done by an agent under a financial power of attorney at the time of application. This is not the kind of trust that needs to be set up 3 or 5 years ahead of time, like we've talked about, and we'll talk about a little bit more. This is a trust that just needs to be done any month that you're looking to get eligibility. So oftentimes this is one of the very last things that we do when we're putting together a Medicaid application, is to get this trust set up and funded for our client. Now notice when I said we're talking about income of the individual, it's only the individual's income, not the income of the spouse. The income of the spouse is not relevant in determining eligibility for a person. So if we've got one spouse who needs the nursing home care and maybe he's got $4,000 a month, and then the other spouse has income and has $5,000 a month, then maybe we're looking at $9,000 between the two of them, and you think, oh shoot, we can't get eligible because we're over the $8,500 cost of the nursing home. Not the case. We're only talking about the income of the spouse who needs the care in determining eligibility. Now, the other spouse's income does come into play when we figure out how much you have to actually pay to the nursing home on a monthly basis. But as far as eligibility goes, it's just the income of the person who needs the care. So let's take a closer look at that. Once someone is on Medicaid, they are required to pay virtually all of their income toward the cost of their care each month. So it's not like someone gets eligible for Medicaid and the state just pays for the care and there's nothing that you have to contribute. That's not the case at all. So the way it works is we look at the individual's gross monthly income. So, and then beyond that, you can keep, don't get too excited here, $70 a month is the personal needs allowance that the person in the nursing home is allowed to keep in order to cover things that Medicare doesn't. Things like haircuts, toothpaste, the nail lady who comes to do nails, whatever it is, you get to keep $70 a month to cover your personal expenses. Also, you get to keep funds to keep any health insurance premiums that you have in place. So that might be that Medicare supplement policy like we were talking about. So you can keep the funds to keep that policy in place and continue to pay those premiums. Clients also always ask me, well, do we need to do that since we're on Medicaid anyway? And my answer typically is yes, because if you leave the nursing home setting, say you end up back in the hospital, you're back on Medicare's dime at that point in time. And there might be providers within that hospital or even hospitals in general that didn't take Medicaid. And so you want to preserve your options and keep that Medicare eligibility in case you have a doctor that doesn't accept Medicaid. And really the money that you would pay for that premium is going to go to the nursing home each month anyway. It's not like it's benefiting you or your loved one to let that supplement policy lapse. So typically the advice there is yes, you do want to keep that policy in place. So again, what we're talking about here is payments to the nursing home each month. So we've got the $70 a month that we can keep for personal needs allowance, we can keep our health insurance premium, and this final one is where the spouse's income does come into play. This is known as the spousal diversion. So Medicaid recognizes that, okay, it's great that spouse number one is tucked away in the nursing home and having all their needs met, but what about spouse number two, who is still out in the community? So Medicaid has decided that spouse number two, who remains out in the community, known as a community spouse in Medicaid lingo, can have at least $3,216 per month in income. That is what the community spouse is guaranteed on a monthly basis. So let's look at how that might play out. If we had, for instance, a husband who had $4,000 a month in income and he needed to go to the nursing home. And then we've got a wife who has $1,000 a month in income. So husband's in the nursing home, he's being approved for Medicaid. We're going to say, okay, he's got his $4,000 a month. He can keep 70 of it for a personal needs allowance. Let's suppose his Medicare supplement is $200 a month. He can keep that. And then we look and say, okay, how much can he give to his spouse each month before paying the nursing home? Now I said she has $1,000 a month in income already. So he can then divert an additional $2,216 per month to her to bring her up to this community spouse minimum standard. So at the end of the day, after keeping $70, after keeping $200 for a Medicare premium, and after paying the funds over to his wife, the $1,216 per month, he would be paying about $2,514 per month to the nursing home. That is known as his patient liability. Now, if we look at that in reverse, let's suppose it was the wife who needed to go to the nursing home and she had $1,000 a month in income. Then she likewise could keep her 30, she could keep her 200 to pay her her Medicare supplement. However, she is not going to be able to divert anything to her husband because her husband already has $4,000 a month in income, which is over the Medicaid permissible amount. So that's how that would work, kind of in reverse. But the amount that you're required to pay to the nursing home each month is known as your patient liability. So in determining eligibility for Medicaid, they don't look just at your income. That's part of the test, but the next part of the test is they look at your resources. So what do you have in your name that is a countable resource? So the applicant who's applying can have $2,000 in countable resources. If the applicant is married, the community spouse who's living anywhere other than a nursing home can have an additional $128,640. So in between as a couple, they can have about $130,000 in countable resources. This sum changes a little bit as well, not necessarily every year, but it does, eke up a little bit. But for the time being, 130,000 is the rule of thumb there. Now, if a spouse is not married, or an individual is not married, then all they get to have is that $2,000 in countable resources. Medicaid is a welfare program, and so therefore the eligibility criteria here are pretty strict. But you will notice I keep saying countable resources. So let's look now at what's countable and what's not a countable resource. So with countable resources, Medicaid's basically looking at what could you access to pay for the cost of your care. So things that they consider to be countable resources are bank accounts, investment accounts, stocks, bonds, CDs, things you would expect. Real estate other than a home place. As you're going to see on the next slide, a home is an exempt resource. The cash value of certain life insurance policies, certain annuities are countable, and certain retirement accounts are countable. However, typically those retirement accounts are exempt resources, and we're going to talk about that in just a second. All right, so between our countable resources and our exempt resources, let's see what the exempt are. A home place. Your home place is an exempt resource. Medicaid will recognize, okay, well, it's great that Heather's tucked away in the nursing home and she's fine and her needs are taken care of, but what if she got better? What happens? She needs to have a place to go. So for that reason, Medicaid allows a home place to be an exempt asset. And if you have a spouse or a dependent living in that house, it's an unlimited equity value. It could be a $3 million house that is an exempt resource as long as there is a spouse or dependent living there. If there's not a spouse or dependent living there, then it is subject to an equity limit, currently $572,000 in equity, and that's a figure as well that changes every now and again. Another thing that is an exempt resource that can be important is a car. And it's important to know that for a couple, it's only one car that is exempt. Now, oftentimes by the time someone's moving to a nursing home, maybe you've already sold that second car. But if there is a second car, the value of that car is going to be a countable asset. So just one is exempt. Typically household goods are exempt unless you own, a Picasso or the Hope Diamond or something like that. Household goods are pretty much going to be exempt resources as far as Medicaid is concerned. And then Medicaid also allows a burial resource allowance. And this one gets a little tricky and complicated. So the easy way to handle a burial resource allowance would be you can set up a CD in the name of the Medicaid applicant or the spouse. So we might have $20,000 in separate CDs set up. And those are designated for burial. When you apply for Medicaid, you say, yeah, we have these two $10,000 CDs, but we agree not to touch them. And those are our burial resources. Medicaid allows you to set that aside because Medicaid doesn't want you to be destitute when you pass away, and then the state is responsible for financing your final arrangements. The burial resource allowance can also be made up of prepaid funeral contracts. The way that works is a lot of times clients will come and be concerned because they have heard about this $10,000 thing, and they say, well, shoot, our burial contract was prepaid, and we paid $13,000, so that's a problem. But actually, usually it's not, because certain things are exempt and don't count. Burial space items, and they're pretty big ticket items typically. So we might have a $13,000 value to that contract, but we're allowed to back out the value of the casket, the vault, the opening and closing of the grave. And so those, like I said, are pretty big ticket items. So even if a contract was valued at $13,000, we might be able to subtract out $8,000 worth of burial space items. So really the value of that contract is only $5,000. And so then we're only using $5,000 of our burial resource allowance, and you can actually go ahead and set up another $5,000 CD. So in order to maximize that $10,000. So I know that's a lot I'm throwing at you. And like I said, the burial resource allowance gets tricky. And the way it also gets tricky is the face value of life insurance counts as part of your burial resource allowance. So if you have a $10,000 life insurance policy, that's it. That's going to be all that you're allowed to have. Apart from burial space items, you could still purchase the casket or a vault. But so overall rule for Medicaid, you can have $10,000 in some way, shape, or form, or combination of these options set aside for burial. Now, the one that I put in big, bold print here, where it says certain retirement accounts, is because this is different in Georgia. It's not treated this way across the United States. And Georgia Medicaid applicants are actually very fortunate that retirement accounts in Georgia are exempt resources. So if you have an IRA, you might have an IRA that you rolled out after you retired, and it's got $300,000 in it. That IRA is an exempt resource. Medicaid does not consider that as part of your $130,000. Now, what Medicaid does require, they require that you take the minimum distributions, which you're probably having to take anyway, those required minimum distributions that every year, except for 2020, you are required to take. And those distributions increase your income. Typically what we have people do when we're looking at applying for Medicaid is we say, all right, you usually get $12,000 a year out of your IRA. We're going to set that up so that you actually get $1,000 a month. And you're going to get that $1,000 a month, and it's going to come to you. It's going to drive up your monthly income. And so therefore it's going to drive up your patient liability, the amount that you have to pay to the nursing home each month. But in exchange for that, Medicaid is going to ignore the $300,000 that's the principal balance of your IRA. And then as long as you've got a beneficiary designated on that, when you pass away, it's going to go to that beneficiary. So we are really fortunate, and other attorneys across the country can't believe it when I'm talking to them about this, that our retirement accounts are exempt. We're not the only state, but it's certainly not everywhere. And so if you might be getting your long-term care somewhere other than Georgia, if you've got children that live out of state, that perhaps you might be moving closer to them at the time you need long-term care, this would definitely be a question to look into and determine what the treatment is in that state, so you don't get any surprises. Annuities can also be exempt. A lot of times people will annuitize their retirement accounts. If it's a retirement account that's been annuitized, that is treated just like a retirement account. And so in Georgia, that's going to be an exempt resource. If you had another annuity that was not qualified funds, was not funded with retirement account proceeds, then that's probably going to be a countable resource. You can set it up in such a way and name the state as the remainder beneficiary of it, and that would make it exempt, but that a lot of times doesn't sit well with most folks. So these are your exempt resources, and anything not on this list you are going to see is going to be a countable resource. So transfer of assets, you can't just, give everything over to your kids today and run and apply to Medicaid and say, hey, I'm impoverished now and I need benefits. And the reason you can't do that, the current legislation is federal legislation that governs the Medicaid eligibility rules. It is the Deficit Reduction Act of 2005. It did bring about pretty significant changes. I had mentioned that, so I've been practicing in this area since 2003. So just about the time I was getting my legs under me and learning how all this stuff worked, everything got overhauled. And it was pretty significant changes when those came along. The Deficit Reduction Act was signed in 2005. Georgia enacted it in 2007, but it was retroactive at that time to 2006. So that was a really fun series of years there for Medicaid practitioners figuring all this out. But some of the main things that it did and the rules that are in place now are it expanded the look back period from 3 years to 5 years. Like I said, you can't just go give everything away, because when you apply for Medicaid, they say, all right, what have you got? And then the follow-up question to that is, have you given anything away? So Medicaid used to ask, have you given anything away in the past 3 years? But now that question is, have you given anything away in the past 5 years? That's what's known as the Medicaid look back period. When I was practicing initially, before the Deficit Reduction Act came into effect, if I made a gift today, the penalty period started running at the time that I made that gift. So I might make a gift now and wait out a penalty period, which I'm going to tell you in a minute how you calculate those. But the clock immediately started ticking. One of the big changes is the Deficit Reduction Act said if you are within the 5-year look back, that penalty does not start running until you are otherwise eligible for Medicaid and actually looking to get those Medicaid benefits. So that means it's not until you're eligible for Medicaid. Well, that's not until you're in a nursing home. So that 5-year look back became it was not only a longer look back, it was a more stringent look back. Now, a lot of people tend to think, okay, if I give anything away, then I can't get eligible for Medicaid for 5 years. That's not true. You're not stuck with a 5-year penalty period, but it's just that there's going to be a 5-year look back period. So let me put some numbers to that and hopefully help this make some sense for you. You will recall that I said the average private pay rate for a nursing home in Georgia is about $8,500 a month. So to keep our math simple, let's suppose that I gave away $85,000. So Medicaid would say, all right, Heather, you gave away $85,000. How long could you have paid for the nursing home with that money? So they would say, okay, 85,000 divided by 8,500, you could have paid for the nursing home for 10 months. So if I made that gift during the 5-year look back, so say I made that a couple years ago, and now I need Medicaid, I go and I apply, I will apply and they will say, okay, Heather, yes, we recognize that, your assets are within the limits, your income's within the limits, but you made this transfer. So starting now, we're starting a 10-month penalty. So for the next 10 months, I'm going to have to private pay for my care. That's what's known as the penalty period. So that is why people often try to just be entirely outside of that 5-year look back if they are going to make gifts. And so there are some other options that are available for planning for Medicaid as well. And let's look at what some of those planning options can be. Of course, the first thing is to spend down. Anything that you pay for, that's fine. Medicaid is not concerned about what you spend as long as it's for yourself. So couples will often ask me, well, gosh, we went on a cruise. Is that, going to be a problem? No, that's fine. As long as it was you on the cruise and not the entire family on the cruise. Medicaid is not concerned with what you've been spending historically up until the time that you apply, as long as that spending was for you. And in fact, this next one, purchasing exempt resource, sometimes that's one of our planning tools or planning strategies that we look at. If I have a couple that's maybe just a little bit over the limit, maybe they've got $150,000 in countable resources, and they've got, they're just a little bit over the amount. You can always purchase exempt resources with that. If someone is going to a nursing home, very often that means there's a house that's about to get sold. And it is fine to make improvements to that house, whether it's improvements for the spouse who is still going to be in the house, Maybe that spouse needs a more reliable car now that they're going to be traipsing back and forth from the nursing home at various hours of the day and night. Any of those exempt purchases are fine to spend funds on. Also, there's the option to make exempt transfers. You know, as I said, I can't just go transferring assets to my kids in order to get eligible, but there are some exceptions to that rule. If I have a child with a disability or a grandchild with a disability, I actually can make transfers to them or to a special needs trust for their benefit, and Medicaid will not penalize me for doing that. So sometimes we have the option, especially in our practice where there is the huge overlap between elder and special needs for our clients. We very often will take advantage of making transfers like that, and it's a great thing to give parents peace of mind, especially if you're caring for a loved one with special needs, because you realize that, oh my gosh, if I spend all this money on me for my long-term care, what am I going to leave to care for my child after I'm gone? And so it's a great benefit to be able to get a parent on Medicaid and then preserve the money as a whole for the child who has special needs. Another big one that I'm seeing more of these days is transferring a home to a caregiver child. If a child has lived with a parent and a doctor can certify that the care that the child gave to the parent kept the parent out of a nursing home for at least 2 years, then the parent can transfer that home to the child without penalty. So it's not that you can't give anything away or that you're going to have a penalty anytime you give something away. Typically that's the rule, but there are some exceptions. And then you might have heard about people setting up trusts and making gifts and waiting 5 years to get everything set up. That is certainly an option if you have 5 years. We do a lot of trust planning, can set up a family trust. You might transfer the house or some investment accounts or anything to that. And that certainly is a way that works if you have 5 years to wait out. If you don't have 5 years, these next two, making gifts and private paying during the penalty period, you can couple that with a loan and do some strategic planning to not get immediately eligible for Medicaid and not protect all of the resources for a community spouse, but you can certainly expedite things and get someone eligible more quickly for Medicaid. We make a gift, we accept the penalty period, but then we make a loan, and the loan generates money to pay for the care during that penalty period. And at the end of the day, at least we've been able to set aside some of those funds to still benefit the person who's in the nursing home, because it can still, Medicaid's not going to cover everything. It's not going to cover a private room. So it is good to have things set aside if we need additional caregivers or therapies. Then we can have those options too. That's what's known as crisis Medicaid planning. And it's done after there's already been some sort of event. People are coming to me because the stroke has already happened. There's no 5 year, even able to entertain that option. So the key here is, and if you were going to take away one thing, hopefully you'll take away more than one thing, but taking away one thing from today is these are options that exist, but you've got to have the good framework in place where someone can do this for you, where you can do this if all of a sudden this happens to your spouse, or where your child can step in and do this planning if you trust them and want them to be able to do all this. So having a good estate plan in place, which includes a financial power of attorney. Georgia does have a statutory form power of attorney. That power of attorney does not convey sufficient enough power without being doctored up in the special instructions and fixing it up some. It does not give enough power to set up irrevocable family trusts or to make gifts in excess of the annual tax exclusion or to make loans. So very important to make sure that you've got this strong framework in place where this can be done later on down the road if you would want it done and if you are comfortable with it. Super important to realize that it's an extremely powerful document when you grant that kind of power. So you really need to talk it through with a lawyer and make sure that you understand what's going on with it. Now, the last thing I want to cover here before we jump into our question and answers is estate recovery. People always say, well, I've heard that if you go on Medicaid, the state can take your house. And there is some truth in that. The Department of Community Health, that's in Georgia, the entity that oversees the Medicaid eligibility, they are entitled to place a lien against the estate of someone who received Medicaid benefits during his lifetime. So if you think back to our example where I said, in that husband-wife example I gave, I said, okay, at the end of the day, the husband's going to end up paying about $2,500 a month for his long-term care. So that means he's paying $2,500 a month. The state is paying about $6,000 a month because they are making up the difference between roughly that average $8,500 a month that it costs to be in a nursing home. He's contributing $2,500, so the state's paying $6,000. The state is keeping track of that. So suppose he was in the nursing home for 12 months and then passed away. So the state would say, okay, we paid $6,000 a month for his care, and that's for the last 12 months. So now we have a $72,000 lien against his estate. So when he passed away, they would say, okay, what does he own that we can file a lien against? Now, if this family had been involved in planning ahead of time, hopefully he's got little, if anything, in his name at that point in time. The main thing that Medicaid is typically interested in is how was the house titled. When I work with couples, I mean, there's no blanket rule, but a lot of time the decision is made that, you know what, we're going to take the house out of husband, if he's the one going into the nursing home. This house used to be titled jointly. We're going to take it out of his name. We're going to put it in wife's name so that then when husband passes away, he does not own that house and Medicaid cannot file a lien against the house. Now, if that didn't happen, suppose husband and wife still did own the house, Medicaid can come back and place their lien and notify the family that they have this lien. However, it cannot be enforced so long as the spouse is still alive. So even if they come back and say, okay, we've got a $72,000 lien against your house, the surviving spouse has the right to still sell that house, to spend all the money that was in the estate. She doesn't have to preserve it. It's just that lien is there. And if there's anything left when she passes away, that lien will still accrue and follow through to her estate and be due upon the time of her death. So there is a $25,000 floor for estate recovery. If an estate is valued at less than $25,000 when the Medicaid recipient passes away, then there is no estate recovery. So that's why I say more often than not, it's a good idea to get the assets out of the name of the spouse who is in the nursing home. Unlike transfers that are made to children, transfers to spouses don't trigger a penalty. So it's fine. If my husband and I were applying and he had $125,000 in his name, we could take that $125,000 and put it in my name because they're still looking at us as a couple when it comes to eligibility for nursing home Medicaid. So getting it out of his name and into my name, it's not accomplishing anything as far as, you know, reducing resources, but it is accomplishing things as far as avoiding an estate recovery lien. So this is also a reason why some people will choose, even though I've told you the house is exempt on the front end, some people will still choose while there's time to set up that family trust and put the house into that family trust, get it completely off the radar so that it's exempt on the back end as well. You know, it's not causing a problem when it comes time to apply for Medicaid. It's no problem. You can have a house, but it's just that it might be subject one day to a lien. And again, I've mentioned that the lien cannot be enforced as long as there's a spouse who's living. Likewise, that goes if there's a child under the age of 21 or a disabled child. So that can all help you avoid that lien on the house in the meantime. So I know I see questions popping up over here. So I'm going to go ahead and transition over to those. Let me pull them over here. So I'll be looking at you. Okay, so the first one was, will I make PowerPoint charts available to the participants? And yes, I'll be happy to do that. I will forward those on and make sure that those go out with the link that you will be getting of the live webinar. Next, we have, with respect to Medicare, you also need to be sure you are actually admitted to the hospital. Here in Georgia, if you go to the ER, go through the ER, they very often put you into a regular room under observation, and those days do not count. Absolutely. So what that was being referred to is, you know, I told you if you go to the hospital and have a 3-day stay and then get discharged to a rehab facility, then Medicare will cover it. Well, getting that 3-day stay has to be 3 days of admission, not 3 days of observation. So that's absolutely correct. Medicaid income does not count. What if you have a bank income from bank account or investments? Okay, so for Medicaid eligibility, you'll remember I said what you pay is based on your income, and it is based on income from any source. So typically it's a Social Security payment, it is a retirement pension, it is those required minimum distributions from an investment account. Also, from a retirement account, also from those investment accounts, that income does count. So that is income that you are earning. But keep in mind, in order to qualify, you can only have $130,000 in your investment account in the first place. So yes, whatever that $130,000 throws off investment income, that will count. But by the time you're applying for Medicaid, it's been driven down to 130, so probably wouldn't be that much. Next, we have retirement accounts. Retirement accounts are exempt if minimum distributions are taken to state law require minimum distributions from Roth accounts that are not required under federal tax law. Yes, the answer is yes. So even if you have a Roth account where the feds are not requiring you to take taxable distributions, that requirement does not. If you've got a Roth, which doesn't have that requirement, Medicaid will still say, oh, no, you got to take those distributions. Does the look back apply to gifts to charity? Yes, it does. Anything that you give away. Now, there are exceptions. If you can demonstrate, if you have been giving, $1,000 a month to the charity of your choice for the past 15 years, and now all of a sudden you need Medicaid, there is an exception that says that any transfers that are made other than the purpose of exclusively applying for Medicaid. So if we can demonstrate a history like that, that means you would have to stop going forward. So going forward, you would have to terminate those, but we can hang our hats on that exception if we can show a clear history. If all of a sudden the day before you apply for Medicaid, you give $100,000 to the American Heart Association, well, that's not going to be viable. But for people, if you've been tithing over the years or regularly, having your IRA distributions go to charity, something like that, if we can show that history, then you can work around it. Next, is there a cap on the amount of money that we can move to a special needs trust to become eligible for Medicaid? There is not. There is no cap. So as long as you transfer that money over into the special needs trust for a loved one with a disability, it's off the radar as far as your Medicaid eligibility goes. Now, it's a special kind of trust. If you have a child with special needs, you might have a third-party special needs trust in your estate plan. And that is a trust that is held for your children or your child with special needs. And then when you pass away, maybe it goes on to grandkids or to charity or whatever. The type of special needs trust that we are setting up in order to get a parent eligible for Medicaid is required to, well, not necessarily, it has some strings attached. So it either has to have a Medicaid payback in it, not at your death, but at the death of your child. So there is a Medicaid payback on it potentially. And so I point that out because we wouldn't necessarily want to put, $700,000 over there just to get it off the radar. If the child has a decreased life expectancy and has had tons of Medicaid care, it's not as, I don't want to say good. It's a different result than you have with a third-party trust. So we need to be careful in doing that, but no, there isn't a limit. In particular, if you're giving to a trust, say for a grandchild who has a disability and they have a typical life expectancy, that money, even a large sum of money, might be gone by the time they pass away. And it doesn't have to have a Medicaid payback. It can be either Medicaid payback or to make actuarially sound distributions during the person's lifetime. So again, you would want to be careful if you chunk over too much money into that trust. If we are required to take amount out each year based on the amount that's in there, that could cause problems for the person with a disability who's receiving the benefits. But as a general rule, it's a great tool if you've got a loved one with the special needs to be able to get a parent or grandparent eligible and set that trust up. Okay, and then I see Charles. Thank you, Charles. Then we've got, would it be advisable to put primary real estate in a trust before age 60, provided good health? There is no blanket answer on that. In my world, I think a lot of you will be happy to hear, in my world as an elder law attorney, 60 is very young. As a 45-year-old, 60 is very young. so I think for a lot of people, if we've got good health, that might be premature, but you never know what's going to happen. And so a lot of it just has to do with the level of trust that you have. Usually it's the children who will be managing that trust. At the end of the day, when we do a trust like this, a lot of people, I think, come in thinking I have some secret magic wand where they're setting up a trust, but they're not really giving up control. You really have to give up control under these for Medicaid eligibility. So you need to be comfortable with knowing that, all right, my house is now owned in this trust, and my kids, whose diapers I changed, are now the ones who are trustees of that trust. And are you comfortable, and do you trust that setup? Now we typically do a rental agreement, a rent back, where you're not actually paying rent usually, other than maintaining insurance on the property and paying for utilities. But even under that, at the end of the day, the kids are in control. And when you decide you want to sell that house, if for some reason the kids say no, well, you can't sell your house, and vice versa. If the kids say, hey, it's time to sell the house. So I would just say blanket statement, 60 seems a little young to me, but you just never know. Good question. Does the Department of Community Health review a special needs trust if they are invisible? Does DCH Medicaid track special needs trusts or require reporting of special needs trust accounts and activities? So the trust, I probably did say invisible, and it is. I mean, as far as eligibility goes, what's in there doesn't count, but it's not entirely invisible. You have to have transparency with it. So yes, let's say if we wanted to get grandma eligible for Medicaid and we're setting up a special needs trust for the grandchild, in order to do that, and the grandchild is on Medicaid, then yes, we submit it to the Georgia Department of Community Health and get it approved. And likewise, each year the trustee is required to continue to stay in touch with the Department of Community Health and account to them for what comes into the trust and what goes out of the trust. And what they're looking for is to make sure that the trust is being used properly, because you can have the most wonderfully drafted special needs trust in the world, but if the trustee is not administering it properly, then it can cause eligibility issues. So they do keep an eye on that. Okay, and then last question here from a name that I recognize. If you own multiple properties, is it best to put all of them in a family trust, including out-of-state property? Out-of-state, in Georgia, we are fortunate. Probate is not that big a deal. And a lot of people will come in and say, I need to avoid probate, I need to avoid probate. And while certainly it can be nice and convenient to avoid probate, we don't have the same motivation as some of the other states, which are where probate costs are determined by how much you have. So when you go to probate your estate and pay the court for that process, it's a percentage of what your estate is. States like Florida operates on that model. So in Georgia, probate is not that big a deal, and so we don't necessarily run to avoiding it because it's just not that difficult or expensive. However, if you have properties in multiple states, that's definitely one of the factors that I talk through with clients and say, okay, do you want to consider a family trust here? Now, whether it's a Medicaid planning trust or just a revocable trust that is designed not for Medicaid purposes, but just to avoid probate. And the reason behind that is if I have a trust here in Atlanta, if I have a house in Atlanta, and then if I'm living a charmed life and I have a beach condo in Florida, and I have a city place in New York City, and I have a lake house in North Carolina, I'm potentially forced with probating in 4 states when I pass away. So it absolutely can be a great idea, set up one trust, transfer those properties into that trust, and then when you pass away, your trust says, hey, when I die, do the following with these properties. And the instructions are all right there in the trust. Your successor trustee takes over, and you don't have to go to court to make that happen. So it definitely can make sense if you've got multiple state properties to put them in a single trust. So that is our last question here. I certainly appreciate it. I can't believe how on time I ended. That was great. So I appreciate everyone for your attention here today. Our contact information is on the slides if you would like to get in touch and get some more specifics on your particular situation. Next month, our webinar will be on guardianship. That's going to be done by Kim Martin, one of the other attorneys in our office. So we will certainly hope to see you there. And thank you again, and have a great rest of your day.